Okay, I'm really excited to be here today. I was talking about being on a university campus again, and there's just something about it. There's an energy that is unique to universities, and I really hope that while you're here, you all really take advantage of it. It's not something that you find as easily once you get out. So when we come back, it's one of those things that you feel, and it feels very good to be here. I'm really excited to be here today. I'm also extremely nervous because this is something I'm very passionate about. And sometimes when you speak about something that you're really passionate about, you have all these ideas, and communicating them effectively can be a little bit difficult. So I hope I'll be able to communicate my ideas effectively. I've titled my remarks, "Women's Humanity Lies Beyond the Law. The law merely recognizes our humanity as women. It does not grant it." And the reason for that is that even as we think about Black women's lives and Black women's bodies, I believe that we have spent an inordinate amount of time focusing on the law, and the law as a means to realize equality. And I think, and I argue towards the end, that perhaps it's time to shift that focus a little bit and to look at other ways to realize equality, that we may have reached the limits of the law as a means by which we can really actualize the practical equality for women. As I was preparing for this talk, I realized it would be impossible for me to give it without sounding pessimistic. So in true lawyer fashion, I'm going to give you my disclaimer. As a lawyer, I am prone to a fair bit of cynicism. It's an affliction I'm trying to cure myself of. It is not contagious, I understand. My partner doesn't have it, so you need not worry. But at this juncture in our history, in the 21st century, as a continent and globally, the fact that we continue to struggle with the acceptance of women's humanity is a significant cause for pause and part of my current rather pessimistic outlook. I don't mean to sound like a downer, and I don't mean to communicate a lack of progress or a lack of hope. I'm merely grappling with the very problematic situation that I believe we're in right now. I'm going to center my remarks around three main areas. The first is the Oj Pistorius case. The second is the role and the limitations of law in realizing women's freedom and equality. And the third is my argument beyond law. How can we accelerate the practical realization of women's humanity and dignity? The Oj Pistorius case, obviously you are all in South Africa, so you've probably followed it way more than those of us outside of South Africa. But one of the first things that struck me when this case hit the headlines, so even before the trial, was how similar it was to, and I'm sure I'm referring to something that a lot of you, as I look through the room, probably won't know a lot about, the Oj Simpson case in America in 1994. And it struck me immediately. This athlete that was well-loved, had a very positive public image, and a beautiful woman, a beautiful white woman. So those similarities struck me immediately, and even as I was following the trial, there were things that were just going through the back of my mind, and I was thinking to myself, oh my gosh, 20 plus years later, and we're doing the same thing, Even initially, before I was preparing for these remarks, I felt like we were not making a significant amount of progress, or the pace of progress was uncomfortable for me. You're well acquainted with the case and the trial verdict that found Oj Pistorius guilty of culpable homicide of Riva Steenkamp. The decision was appealed, and the Supreme Court of Appeal found that the trial judge had erred in law, and the appropriate verdict was one of murder. The Constitutional Court has since declined Oj Pistorius' leave to appeal. The trial court shocked many of us in South Africa and around the world, but why were we shocked? I think we were shocked and angered because women especially have assumed that legal equality would inevitably pave the way for our full recognition as human beings, with all the rights and privileges attendant thereto. So we're shocked by decisions, such as the trial judges, whose foundation is a lack of acceptance of women's humanity. And I say that because by not accepting our equality, it follows that we're then not fully human, because you can't be a person and be part human. So we either are human and equal, or we are unequal and not human. And the way the law has looked at women, and in this case it was a white woman, and I want to argue that if this is the way white women are treated, then black women can only expect to be treated worse, not better, by the law. A decision like this rocks the foundation of our feminism and makes us question the progress, or at least makes me question the progress, of the struggle for freedom and equality. In some respects, the appellate decision is redeeming, but not entirely so. I want to argue that if the law is a reflection of society, then the inconsistency in the trial court decision and the appellate decision reflect, at best, a mixed bag. It means that we're not really sure as a society then where women stand, right? I think it's very easy to say, yes, the appellate decision got it right, but we can't ignore the trial decision. In many cases, the appeals process doesn't happen for one of many reasons. As a white man, Oscar Pistorius was in a particularly advantaged situation in the justice system. So he had an opportunity to go through all the motions. So it could have gone either way. And unfortunately, only subsequent decisions will indicate which direction the legal system is leaning towards. I think it's too early to tell whether there is a change in the jurisprudence in South Africa. But I do think it tells us some very interesting things. I'm going to be a bit of a boring lawyer here and tell you some things that were really kind of fascinating me. They're small things, and then I'll get away from them, but it's hard to undo training. So the facts of the case as they were outlined in the initial judgment is one of the things, and the other one is the social context, and the social context will lead us forward. So the facts were that Oscar Pistorius was actually charged with 4 counts, and only one of them related to the murder of Riva Steenkamp. The other 3 related to discharge of a firearm, actually, and one was to unlicensed ammunition, possession of unlicensed ammunition. See a pattern? It was uncontroverted that the murder occurred around 3 a.m. in the morning, and that Riva Steenkamp was murdered in a toilet cubicle, a small, locked toilet cubicle. I don't know about you, but when I go to the bathroom at 3 a.m. in the morning, I barely open my eyes. So why would she lock the door if there were only the 2 of them? These facts are important because the interpretation of the facts and the law is for the judge. A judge with little or no knowledge or understanding of intimate partner violence is unable to see the red flags that you and I may see. And in this case, both the trial and appellate judge failed to see anything amiss. This leads me to the social context. The prosecutor tried and failed to prove to the trial court that the accused and the deceased had had an argument prior to the murder. The trial judge said it wasn't proved beyond a reasonable doubt. Okay, but her being locked in a toilet cubicle at 3 a.m. in the morning was. So we have this discomfort, this situation where the facts can lend themselves to an interpretation, but there has to be an interpreter who understands the context. And I think that that's one of the reasons why the legal system is always going to be limited in its ability to deliver equality for women. Because we can't touch every single one of those people in the same way. Some of them will be better than others. That's not to say we shouldn't try, but just to understand that incongruity is going to remain. It struck me as odd that despite the significant data and research on intimate partner violence, neither the trial nor appellate court considered or referred to this social context. There's a lot of data on this topic. Suffice it to say it is well researched and well documented, including in South Africa, so globally and in South Africa. I'll cite just one paper, a research brief published by the South African Medical Council in 2012 entitled Every 8 Hours, Intimate Femicide in South Africa 10 years later. It examined cases from 1999 to 2009 and noted a general decrease in homicide. But femicide was disproportionately resistant to the trend, meaning that femicide is not linked to homicide per se. It further found that even with a decrease in female homicides, intimate partner femicides did not decrease. So women being killed in an intimate relationship is no real reflection of the general criminality of the society. And I think that's particularly, well, scary, frankly, because it means for all of us in intimate relationships, especially with male partners, that you are at an increased, the research shows, level of risk in that relationship for violence and for fatal violence. So the absence of this social reality in both judgments for me is very significant. I suggest it means that there's still resistance to the reality of women's lives as full, as equal, as human. That the data demonstrates the pervasive and serious danger that women disproportionately face for being women, and that this danger is compounded when we are in intimate relationships with men, is still perceived by the judicial system as, somewhat suspect. Yeah, well, we're not so sure it's something we should bring into the hallowed halls of justice. And this is why I want to argue that we need to move beyond the law. Because if the law has the right, and it does, by the way, to refuse to accept these realities that are our realities as women, then we really must find a way to influence other areas of our lives so that we can realize our equality. I want to talk a little bit about the role and the limitations of the law in realizing women's freedom and equality. And I was especially excited by the Vice Chair's remarks because I think this is where we start to retell our story and to own our story in a different way. So lawyers and judges are usually interested in the law on a particular set of facts or circumstances. And so the question they usually ask, I usually ask, is what's the law that applies in this case, in this particular set of circumstances? In contrast, the philosophy of law asks the larger foundational question, what is the law, capital L? This question presupposes the existence of a certain set of universal characteristics, and that's open to debate. The philosophy of the law reflects the society in which it emerges or emerged. So one of the things we have to take very seriously is that even as we engage with the law carries its history with it. We have not yet replaced that. So even as we engage, we can't erase the history. It filters in, and I think decisions like this remind us how powerful that history can be. It's a fact that the struggle for the recognition of women as central so the law is not independent of the social political order. The very foundations of the law we apply is uniquely male. Put another way, if the philosophy of the law were human, not male, it would encompass, not accommodate women. As it is, the law accommodates women as other. It is in fact this struggle for the recognition of women as central, not peripheral to the law, that is in large part at the heart of the challenge of justice for women from the legal system. That black women are at the end of the spectrum of women means that we bear the brunt of this. The way women have sought to influence and change the law has been in primarily two ways. In the interpretation and the application of the facts, as I was talking about before, in particular situations. And secondly, in the abstract, law is a possibility for a different relationship and power dynamic between men and women. And I want to argue that the women's movement has been successful in the former, but not so much in the latter. And I want to ask the very difficult question, what is it the law cannot do? And by that, what is it that we should not ask the law to do? The rarefied status of the law in our societies on the African continent, especially, is an accident. It's a reflection of our colonial and oppressive histories and the use of law as a means of oppression and subjugation of black people. Globally, the law serves the normative function of guiding human behavior. But in Africa and some other parts of the world, it is used to control black people, to limit and restrict our lives, and especially the lives of black women. This we already know. But recognizing this unique historical role of law in African society should lead us to ask how suitable the law is as the primary means of transformational change in the realization of women's equality. The law has been the primary means by which women have waged the struggle for gender equality on the continent and indeed globally. We have focused very singularly on the law, and perhaps rightly so for the past half century or so. that we have made progress, indeed significant progress, but perhaps we may be reaching the limits of that progress. We've been focusing on equality, which we have secured and will continue to secure, primarily through changes in the law, and it may be time to expand our focus to equity, which of necessity takes us beyond the law. If we looked at the law and legal rights alone as a barometer of women's freedom and equality, it would present a picture that is in stark contrast to the reality of women's lives across the continent and indeed the globe. I was thinking about rural Black women, and if we look at what our status is under law and what the realities of their lives are, they are two completely different things. In the World Bank policy paper, Women, Legal Rights Over 50 Years, Progress, Stagnation, or Regression, the researchers examined gender gaps in the following areas, among others: equality or non-discrimination as a principle in the country's constitution, the ability to sign legal documents in one's own name, so legal status or capacity, and the ability to access and own assets. They found significant progress in the laws that restrict and or constrain women's rights, with over half of the constraining laws noted in 1960 being removed by 2010. Interestingly, the paper also noted that there was no direct link between a country's development and the reforms in terms of women's rights. And I think this is something else that in Africa we really need to be serious about. Development does not mean that naturally women will access equality. So we must look at those two things as intertwined, interlinked, but it's not a causal relationship. You know, I was reading this and I was like, well, we feminists could have told you this. We've been saying that, you know, equality is not a natural progression for a long time, that it is as a result of women's struggle. So, you know, I think there are two lessons here, and I see Professor McFadden nodding, and one of these is her lesson, which is one, you know, listen to the feminists, we get it right sometimes, more often than not, I might want to say, and feminists need to demand to be acknowledged for our contributions to this discourse. We are having our struggle, our theories proved right, but we are not getting the acknowledgement for them. And I'll note a little later that that might be why there's this contradiction about, I don't know if I'm really a feminist. Well, why wouldn't you be a feminist if you can vote because of feminism, if you can own land because of feminism, if you can access healthcare because of feminism, you know? But it must be because you don't ascribe those benefits to feminism. So who do they ascribe those benefits that we fought for, that we've all been fighting for too? And in that way, we are giving away our power. So we really must fight for that acknowledgement. In the No Ceilings Full Participation Report, which was a collaboration between the Bill and Melinda Gates Foundation and the Clinton Foundation, they found that 4 out of 5 constitutions have some guarantee of gender equality. In addition, that in 76 of the 100 countries surveyed, laws prohibiting domestic violence were up from 13, that in 76 of the 100 countries surveyed, they had laws prohibiting domestic violence, which was up from 13 in 1995. So the law has changed. It is changing. But the report also recognized that the pace is extremely slow, and this is one of my issues. In the area of women's leadership, for instance, it found that in 1995, there were 12 countries with a female head of state or head of government, and in 2014, that number had grown to only 18. Laws across the continent and the globe increasingly recognize women's equality and provide for the expanded rights of women. But we're not realizing those rights. So the promise is there again. I mean, I think for me, what I really want us to start to take seriously is that we are given this promise, but we're just not able to collect on this promise. It's like a bad check, or each time you go, they tell you, no, come back tomorrow, you know, come back the next day. The promise is there. That's what the law is. It's the legal instrument by which to secure the promise, and we've secured the promise. The World Bank's report also offered some insight into 2 trends that affect the pace of progress on gender equality. The first was what they call the CEDAW effect, and they found that within 5 years of ratifying the Convention on the Elimination of All Forms of Violence and Discrimination Against Women, countries had enacted legal reforms to remove restrictions on women's rights and participation. They also found that the increased number of women in political representation at the national level, over 25% was their indicator, created an enabling environment for the reform of discriminatory laws. And I think this offers us valuable clues about how to rethink and re-strategize for the next phase. I think the progress that I've noted is a testament to the success of feminist theories in provoking the rethinking and the review of laws so that they reflect and they serve women better. But I want to pause here and suggest that despite this success, and it is a major success, I'm not belittling it, we've largely not gained acceptance of the fundamental underlying belief of all feminist theories that women are human. And I posit that this is why we continue to see the legal and administrative decisions that, despite the laws, dehumanize women. This is what I mean when I assert that we've not been as successful at changing the law, right, the capital L law, as possibility for a different power dynamic between men and women. Women's practical experience and interaction with the law has changed, but only marginally. We're still searching for justice from the legal system. A system that continues to resist altering its core male reference point to human, and it is inevitable that we will have decisions that reflect the failure to recognize women's humanity as long as the system holds true to this core. So the Pistorius case is really, for me, an example of a case where a particular woman's life is devalued, but it's also an indicator about how we are able to impact the legal system, and perhaps the pace at which we can impact it. And is that going to be okay for us? I'm not comfortable with the pace, I have to tell you. And I think that this case is also interesting in light of another case, which I actually just saw on TV, I think yesterday or the day before in the evening, of the woman, Sindisiwe Mankele, who was found guilty of the murder of Flaba. And this week, actually, she was sentenced to 12 years in prison. And Oscar Pistorius initially had 5, and he shot 4 bullets, right? She stabbed him once. Similar circumstances, intimate relationship, domestic environment, 1 stab wound, but the perpetrator in this case is a woman. And there's little angst in the decision to arrive at a guilty verdict. I'm not minimizing the crime, but it is the circumstances of the crimes that I mentioned to you earlier that create the opportunities for obfuscation within the legal system. Those are the opportunities that the judge uses to basically imply or insert his or her bias. And I want to draw your attention to the fact that the victim is a man. In the juridical mind, it seems much clearer, less prone to distraction about the nature and value of the loss of human life when it is a male life. Another reason that the law on the African continent is limited as a tool for transformation is that, as a general rule, we have a somewhat tenuous respect for the rule of law. I know a lot of people might challenge me on that, but I think it's important to be honest with ourselves. The reason the law is powerful is because there are consequences for non-compliance, that the law is enforced when violated. But if we live in jurisdictions where the enforcement of the law is not certain and predictable, then the law loses its normative power to guide human behavior. I will do things that are illegal because I will not get punished for doing them. I'll give you an example of Kenya. So in 2010, we promulgated a constitution that for the first time in our history recognized the equality of women as citizens and the right of women to have equal opportunities in the social, political, and economic realm. The Constitution also provided a right to public leadership by requiring in Article 27(8) that not more than 2/3 of the members of elective or appointive bodies shall be of the same gender. Some people call it the 1/3 rule. I like to remind people it's not more than 2/3. It's a limit on male power. The last 2 cabinets, though, have violated this principle, with more men than permitted by the Constitution. What happened? Nothing. So we have to wonder about using an instrument that when violated has no consequences, because then what we have are paper rights, and paper rights don't change our lives. We still are unable to live our lives the way we want to. In 2015, myself and a group of women went to court on a certificate of urgency before this last cabinet was appointed. And I laugh as I'm reading this, although I was so upset at the time. I mean, I was practically crying, but I don't know why it's kind of funny now, because I mean, sometimes some of the stuff that happens on our continent just blows the mind. So we went to court in December, and we went on a certificate of urgency, and we said, you know what, we need an injunction to stop the president from appointing cabinet because it violates the Constitution. And the judge in chambers did not bother to come and see us, said, you know what, come back in February 2016. We're like, okay. Did we not tell you that this is important, that they're going to appoint the cabinet? Okay, so we lost that. And I mean, going back home, it was horrible. You know, I was just so upset because here I was, I mean, as a lawyer, and this is one of the reasons why I really want to suggest to you we need to go beyond the law. I believed the hype, you know, this is the thing that will change everything, the law. So I'm like, come on, really? You know, how can you do this to us? So fine, just last month we went to court again, you know, we're ready. And well, we had to amend our pleadings because they appointed cabinet in the interim, obviously. And we have a date in April. So as I speak to you today, we still have to wait until April for a hearing, and we're not really sure it's going to proceed in April. So in a continent and a country where the rule of law is not well respected, is not a fundamental principle, one which nobody threatens, it's very, very difficult to use the law as an instrument for social change. When the law isn't a deterrent, it has limited efficacy in guiding behavior. So I want to suggest that we must see issues of the rule of law. Whenever you see that, don't gloss over it and move on to the next article or move on to the next thing. You must see issues of the rule of law as inextricably linked to women's equality struggle. Because until that happens, we are not going to be able to realize the promises of the laws that we've changed. So it seems clear to me that legal status alone is not sufficient for the equality of women. It's necessary, but not a sufficient condition. Otherwise, we would have realized equality by now. So this very difficult decision, because it meant that I had to also devalue some of the status of being a lawyer and of being involved with the legal system, came from just this angst that I had that, you know what, this pace of progress is just, it's not good enough. And partly because I'm a child of the 70s, and the expectations created in us for a more equitable and just world were huge. I mean, we were witnesses to the adoption of CEDAW, the UN conference in Nairobi in '85, Beijing in '95, new constitutional dispensations in the continent, and a general expectation that our lives were not going to be like our mothers or our grandmothers, that we were going to be able to do anything we wanted, right? Girls can do anything. You can be anything you want to be. The sky is the limit. We've all heard, and some of us have uttered these words to the girls and women in our lives. Well, when these expectations meet the hard realities of patriarchy, the disappointment is profound. And I want to suggest that if I'm this disappointed, and I'm excited to see the young women here, so we can check if this resonates with you. You know, what are the expectations of the younger women, the women coming after me? You know, are they as high or higher? And so what's their response going to be? And I usually tell this to the men who find me extremely aggressive, and I tell them, listen, if you think I'm bad, I'm telling you, the guys behind me are certainly not going to be as nice as I am. So we're living better lives, we have more freedoms than ever before, but it's simply not enough. Our individual and collective aspirations are still circumscribed, they're still limited by factors outside of us. The expectation for myself and for many younger women is not for a promise of equality at some indeterminate future date, but the reality of equality now. So I am deeply impatient. Some people argue it's a character defect. I'm going to try and use it for good, right? So if we decide that we need to move a little faster, then I think we need to start looking at how do we move faster. I'm really looking forward to the upcoming panel on young women, young, black, and feminist in South Africa today, challenges and celebrations. I really want to hear what younger women have to say about the pace of change and what the unique challenges are for them. And also, I'm excited about how they're using different mediums to really propagate the message. I think the next frontier for feminism is to extend and expand its influence beyond the law. As we grapple with the intersectionality of race, class, sexual orientation, we are still being forced to be more inclusive, and I want to argue that we must be if we want to succeed. By expanding our reach, we can multiply the change agents actively challenging patriarchy and ensure support and progress is made, and it is more broad-based and sustainable. I also think it would be faster. I don't think I'll do that. So I've told you this has been an extremely difficult part for me, and I'm sure I'm going to rewrite it when we do the paper. But beyond the law, how can we accelerate this practical realization of women's humanity and dignity? So I believe this is where we need to be engaged. And we're here of necessity because of success, not failure. I want that to be clear. You know, sometimes the problem is you actually succeed at what you're doing, so you keep doing it, and you don't pause to reflect and review, okay, I'm succeeding at this. Perhaps some of us need to stop and do something else. So we're here because of the success. But we need to start having different conversations, embracing greater engagement with the political and economic realm, and bringing more women in and helping more women understand how they are beneficiaries of feminism. And this is particularly troubling for me because I think if we lose the right to claim that we, feminists, women who have worked so hard, are the ones who helped realize these benefits for women, then women will say that men did this. And we will be back to actually we'll be worse than we were before. And we will have lost an opportunity to help women, especially women in rural, isolated areas, understand the power of women. So I think this is really important. But I'm going to have a conversation, the next 2 bits, about things that are not usually discussed at conferences like this. The economy, economic opportunities, and politics. And why? Because I think we're starting to see clues about how we can engage in this next level. So the Africa Development Bank says that women in Africa are more economically active as farmers and entrepreneurs than in any other region in the world. Can you imagine that? You know, and this for me was really exciting because when I look at these numbers, and I'll give them to you, I wasn't sure I was going to, but I'll give them to you. So in Nigeria, 41% of women are entrepreneurs. In Ghana, 28%. Uganda, 25%, Botswana, 20%, and South Africa, this is really interesting, 9%. But what does that tell you? There is potential if 4 out of 10 women in Nigeria are entrepreneurs, and only 9% of women in South Africa are entrepreneurs, then there's latent potential there for us to expand this discussion and these opportunities for women. I mean, looking at this data, I was also like, there's definitely something going on there in West Africa that we need to figure out, bottle, and perhaps export to the rest of the continent. But it tells us that women have used the expanded legal rights to venture more aggressively into entrepreneurship. And that's a great thing. That's what we were fighting for. So how can we leverage on this trend and engage with women entrepreneurs and policymakers in this space to entrench notions of women's equality and expand women's role? It's a similar strategy to what we were doing within the legal system, but applied very deliberately to the economic and the business space. And for me, this is also, it's something that I encountered personally as an entrepreneur. There were things that I just felt, well, this is one space where if I'm good enough, surely, it's going to be a meritocracy. And, you find there's a preference not to do business with women. And again, just like we found in politics, until we have a critical mass of women so that we are able to choose and have a network that can expand that space, it's extremely difficult to break in. Another report that just shows the potential of women is by the International Finance Corporation, and it's in the boring topic of insurance. So this report is entitled She for Shield. It found that by 2030, which is about 14 years from now, the insurance industry is expected to earn more than $1 trillion from women alone, only. And I know this sounds like, well, but it's commoditizing us, we're uncomfortable with that. But what does it say? It means that they've ascribed a value to us. We know our value, but they didn't know our value. So now when they've ascribed a value to us, I think this is one of those times we must learn from patriarchy. We must be a little more agile. We can co-opt discussions for our own benefit. So insurance industry, if you think we're valuable as women, I want to talk to you about your policy. I want to talk about the dates that, that policy affects. And I want to ask you why you're not covering certain conditions that are unique to being female. So this is power if we use it collectively to realize what we want to do. So I don't want us to resist the commoditization of women as a class if it is the way we start to have the discussion. We concede nothing through the engagement. But the engagement offers us an opportunity to inject feminist theories into that space, which we had in law. So that's what we're doing. When we leave these spaces untouched by feminism, then we are actually grounding patriarchy. We're leaving the economic space free. So we've been working in this legal realm, but the economic is free. So how are we really going to unseat something if we're not challenging it in all its various strongholds? And the economy is one major stronghold. So these are two examples where the society is recognizing our worth, and we can expand our influence by engaging. I also think that it gives us an opportunity to engage with more different women. Because if my aspirations are entirely in business, and I've been previously just unconnected to the women's movement and women's struggle, then we can now start having a discussion because we have an alignment of interests. And that expansion is going to be critical for us, I think, in the next phase. Finally, I want to just talk about politics, not in the sense of, running for political office, although I think it's critically important that as feminists, we start to identify candidates that are women, that reflect our feminist ideology, and that we can advance in the political realm. So that's just an aside. But I told you how the No Ceilings report found 4 out of 5 constitutions guarantee a mechanism. But it also found that almost twice as many women are in political office today compared with just 20 years ago. So in 20 years, we've doubled the number of women in political office. It's not enough, in my view, but that's significant. That's huge. And maybe that's why we're also starting to see, I can't say a change in our politics, but discussions, we're starting to be heard a little more. It doesn't mean that we're accepted, but we're now no longer speaking outside the room. Sometimes our voices do enter the room, and I think we need to now deliberately strategize about how to make sure more of our voices are in the room. In countries like Rwanda, they're leading in terms of women political representation. Rwanda has more than 50% of women in the lower house in parliament, and according to the World Gender Gap Report, the last one, they were #1 in the world on women's political representation. And this also tells us something else. There's an opportunity to leapfrog. That just because we've been moving at this pace does not mean we will always move at this pace. And that the countries that were probably least, I'm pretty sure no one would have said Rwanda would have been here 20 years ago, 30 years ago. But it is because they had a sense of possibility about themselves. And I think that's what we need to start doing again, is the sense of possibility for ourselves as women. Women have significantly more power than before, and feminism has helped ensure these benefits for women across the world. So again, as I was telling you, why are women refusing to identify as feminists? And that has to be a concern for us. I know, a lot of feminists have been like, well, why should we care? I'm feminist, so it doesn't matter. You'll get conscious one day. Well, no, actually, we really need to care, because when we don't engage them, when we do not help them understand that they are able to do what they want to do, whatever that is, because of feminism, then they fail to understand the power of feminism. We don't associate with patriarchy because it's good to us. We associate with patriarchy because it's powerful. So we must show the power of feminism in order to attract more women to our side. And I think that that's critically important for me. I was looking on the Twitter timeline yesterday, and this New York Times study about, oh gosh, all these women who don't associate with feminism, most of whom are black, but also conservative white women. And, again, talking about the intersectionality, the importance of that. And what underlies that for me is that we really have to work on being inclusive, but we also must shed this underdog mentality that we have had. Because let me tell you, lots of people hate being underdogs, And maybe to the people in this room, because they're fighters and they stand on what they believe, that doesn't seem like a big deal. Well, think about it. The vast majority of people who are being led want to associate with a winner. So we have to show that feminism is winning. In this battle, we're winning. So you know what? Come to the winning side. So I want to leave you with two things. One, we have to figure out how to be inclusive, to start having conversations that we were not having before. Inject business and entrepreneurship. And I think that's a real challenge for South Africa. 9% means there's amazing opportunity there, especially when we look at, on this continent, this is the most developed economy. And I know there are all the historical challenges, but I also think that it presents us another way to look at inclusion, which is transnational. Going back to looking at, if Rwanda's been able to do this, what can we learn from Rwanda? If Nigeria's got 41% entrepreneurs, what can we learn from Nigeria? So learnings within the continent, especially because there's a lot more similarities around the continent. And can I tell you something else? Africa is starting to be the learning ground for the rest of the world on so many of these issues, including on entrepreneurship. I was a Vital Voices Fellow in 2013, and you would hear a lot of the data is coming from Africa on SMEs, and especially on women-owned businesses. So here we are, the rest of the world is learning from us, and we're not learning from each other. We really need to bridge that gap. I think it's critically important. The other big challenge is, how do we use this power? How do we wield it to ensure that our society recognizes our humanity and dignity in all realms? But also, how do we use it to reimagine? As I was preparing for this talk, I thought, if someone told me, well, you know what, close your eyes and tell me what the new order you would like is, I would have just told them the law. I need laws that do this and this and this and this, and please don't restrict me from doing this. But beyond that, what would it be? What does it look like? And I think that's why it's exciting to see people in media, because those are the stories. You start to give us options. We start to see that it is possible to be, an accountant and go into law and be a journalist and be an author. It is possible to be many things. And that's really important, that we start to think about, what does this look like? Not what it isn't, what it is. And we've been doing a lot of what it isn't. And then I want to suggest that we need some sort of deadline, not like a hard and fast one, but what can we accomplish in our lifetimes? We've seen the pace of change. I'm telling you, I'm uncomfortable with it. I'm looking forward to this panel and to hearing what young feminists have to say, if they're comfortable with the rate of change. But what is it we want to accomplish? And if we know what it is we want to accomplish in our lifetimes, then we can strategize around that. We can align our interests and focus our attentions a little more around some of these issues as well as other issues, but in a way that gives us sort of an assessment. And the reason I think that's important is because this moment is created but we can also create the moment for the next reflection. And I think that's what our lifetimes would be. So thank you very much for the opportunity to speak to you. I want to really thank you for your attention. I know they've been a bit heavy in terms of the law, but I'm really excited to hear what you would imagine this next phase of feminism is.